Hey guys and girls, welcome back to another edition of Freedom Steel, following up on the recap of the hearing for House Bill 5855. I'm Todd Vandermeid, former NRA contract lobbyist and Illinois' all-around gun law guru. So here we have, we're going to play my testimony in front of the committee, and it's just testimony that we had. So this panel was made up of Ed Sullivan from the ISRA, John Weber from the National Rifle Association, and myself. We decided to split up the testimony, and my focus here was to focus on what the courts have done from Heller to now including New York, and tackle some of the issues that have been brought up here. So with that, gonna play this. You can tell I'm racing through my testimony just a little bit. When we got there, we had originally been told we were going to be allowed the time that we needed. They told us they wanted us to try to keep it to 5 minutes. Even with editing out my testimony there, I don't normally read a lot, but there are so many quotes from the courts, I had to have it in front of me so I could read it. And my testimony went almost 13 minutes. And then that's with me paring down or cutting out about a page of it that I had in there. So with that, let's get to the show.
We are going to move on to Mr. Vandermeer.
Thank you, Mr. Chairman, members of the committee. Todd Vandermeer, former contract lobbyist for the NRA for over 25 years, currently with the Firearms Technical Group. I'm going to focus on the law and what has been happening in the courts recently. So in 2008, the Supreme Court in Heller affirmed that the Second Amendment was an individual right. The Second Amendment protects the individual right to possess a firearm unconnected with service in the militia and to use that arm for traditional lawful purposes such as self-defense within the home, striking down the District of Columbia's handgun ban. In 2010, the court found a similar ban in Chicago violated the Second Amendment via 14th Amendment. Anti-gunners had attempted to limit the reaches of Heller, often saying that the ruling was limited to handguns and possession inside the home. Nothing could be further from the truth. Heller applied to all lawful uses of firearms within or outside the home. Heller rejected interest balancing in deciding Second Amendment challenges. Heller applied to modern firearms, even those not in existence at the time of the founding. Heller protected the possession and use of firearms that were in common use at the time. In 2021, the court heard New York State Rifle and Pistol Association v. Bruin, a challenge to New York State's May issue carry law requiring a good and substantial reason in order to obtain a concealed carry license. In a 6-3 decision, the court found that law unconstitutional and indicated so were the 7 other states may issue carry laws. The court then took this opportunity to chastise lower courts for misapplying the test enumerated in the Heller decision. They enumerated a new test which rejected any interest balancing and instead relied upon the text, history, and tradition to determine if a law was constitutional. Quote, despite the popularity of the two-step approach, it is one step too many. Step 1 of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text, as informed by history. But Heller and McDonald do not support applying means and scrutiny in the Second Amendment context. Instead, the government must affirmatively prove that its firearm regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. New York applied Heller and set about correcting the lower court's wrongful interpretations. In keeping with Heller, we hold that the Second Amendment's plain text covers an individual's conduct. The Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if a firearm regulation is consistent with the nation's historical tradition, may a court conclude the individual's conduct falls outside the Second Amendment's unqualified command. Not only has the Seventh Circuit ruled that the right to keep and bear arms applies to carrying firearms outside the home. I was one of the architects of setting up the concealed carry case. It has also found that the right to acquire firearms and the right to train or practice with a firearm is connected with the right to keep and bear arms. So under the New York test, House Bill 5855 clearly covers conduct that the plain text of the Second Amendment, which the court said the Constitution presumptively protects that conduct. Acquisitions, possessions, training, self-defense are clearly protected conduct under Heller and New York. Throughout the hearings on the subject matter, there's been an undertone we have to do something. This is a first good step. These are weapons of war. They have no place in our society. We're not banning all guns, just these so-called assault weapons. No matter how you dress it up, everything that's been discussed prior to this is to justify the bill in front of us is interest balancing approach, something expressly prohibited in the New York decision. Quote, moreover, Heller and McDonald expressly rejected the application of any judge-empowering interest balancing inquiry that asks whether a statute burdens a protected interest in a way or to an extent that is out of proportion to the statute's salutary effects upon other important governmental interests. The Second Amendment does not permit, let alone require, judges to assess the cost and benefits of firearms restriction under means and scrutiny. We decline to engage in means and scrutiny because the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. We concluded a constitutional guarantee subjected to future judges' assessments of its usefulness is no constitutional guarantee at all. Page 13 of the Bruin decision. They went on to set forth the test we set forth in Heller and applied today requires courts to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. Heller was clear, and despite the courts misapplying it for 13 years, New York corrected that. They reiterated that. They reiterated that judges and courts are not to give deference to legislative bodies or use intermediate scrutiny. Quote, if the last decade of Second Amendment litigation taught this court anything, it is that federal courts tasked with making such difficult empirical judgments regarding firearms regulations under the banner of intermediate scrutiny often defer to the determinations of legislatures. But while that judicial deference to legislative interest balancing is understandable and elsewhere appropriate, it is not the deference that the Constitution demands here. The Second Amendment is the very product of an interest balancing approach, and it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. It is this balance, struck by the traditions of the American people, that demands our unqualified deference. We've heard some other people testify about Highland Park, and that Highland Park's ruling or ordinance was found constitutional. Highland Park, the district court found the ban constitutional. The Seventh Circuit Court of Appeals found that it was constitutional, and the Supreme Court refused to hear that, all pre-Heller. That's a fact. However, in the Highland Park decision, they said, Judge Easterbrook, if it has no other effect, Highland Park's ordinance may increase the public's sense of safety. Mass shootings are rare, but they are highly salient, and people tend to overestimate the likelihood of salient events. If a ban on semi-automatic guns and large-capacity magazines reduces the perceived risk from mass shootings and makes the public feel safer, as a result, that's a substantial benefit. If it makes them feel safer is the exact interest balancing approach that the Supreme Court in New York has rejected and forbidden. 4 times in the Friedman decision, they used intermediate scrutiny in their discussion. And then they went on to say the features prohibited by Highland Park's ordinance were not common in 1791. Most guns available then could not fire more than one shot without being reloaded. Heller explicitly addressed this issue. Quote, "Some have made the argument, bordering on the frivolous, that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding." Friedman got it wrong at every turn. The table has been reset, according to the judges of the Seventh Circuit Court of Appeals at oral arguments last month. One judge, the chief judge, going so far as to say that the Second Amendment has gone from a second-class right to a supercharged right. And I'm here to tell you that the gun owners are tired of being blamed for every madman, every criminal, and every other depraved act that 2.5 million gun owners didn't do. And we're not here to negotiate. I'm here to tell you that if House Bill 5855 or anything remotely like it passes, we will see you in court. We will take that to court with 4 Supreme Court decisions behind us, because I don't think you're asking the right questions. The question should be, how are you going to enforce this? What are you going to do when you have less on the books tomorrow than you have today when the courts get done with this? The Attorney General is complaining about 20 lawsuits that are currently pending. I'm going to tell you, there's probably going to be another 20 in the next year. The FOID card is on the cusp of potentially being revoked and found unconstitutional. There were no permits to purchase in 1791, which is the standard that the court has announced. You have 70 counties, as Mr. Sullivan talked about, that are sanctuary counties in the state. Last week, you had Iroquois County pass a resolution to their county officers saying there will be no county assets or expenditures in use of enforcement of House Bill 58 or anything like it. When New York and other states passed this kind of law, they got about a 15% compliance rate with the registration. The penalties in this bill make me a Class 2 felon if I have my carry gun and one other magazine with me. That's ridiculous. The fact that, people have been asking for fingerprints for the last 2 years. No matter if that bill had passed, no matter how many fingerprints, the 360 background checks I pass every year, no matter how many carry licenses I have in my pocket, it's never enough. And so I don't know how you're going to enforce this. You can't put us all in jail. Your new bail law just said you can't do that. You will have civil disobedience to where people aren't going to register things. They're not going to surrender things. They're not going to turn them in. So I ask you, what is the enforcement mechanism? Are you going to send the state police house to house? Because as one local law enforcement chief put it in my area, he said, "Todd, you're telling me that I have to go potentially arrest my neighbors, people I go to church with, the people on my son's football squad, the people that come over and barbecue, the guys I see in the bar, they're all now felons?" I don't think that question has been thoroughly thought through. And so, with that, I think you're going down the wrong road. And to sit there and criminalize 2.5 million people in this state, the numbers that we're talking about here are staggering, and I'll be happy to answer any questions.
Okay, thank you, Mr. Vandermeer. We'll finish.
Keep it down, guys.
We'll finish with Mr. Weber.
Well, guys, there you have it. That was my testimony in front of the committee considering this big gun ban with House Bill 5855. I'll do some more on the give and take and the questions and some of that stuff that we had going on, as well as some of the other testimony that was given. But for everybody that didn't have 3+ hours to sit through all this and wait for our guys to show up. I just wanted to shorten this up. I'll do some more running commentary on it after this, but want to keep this video, under 15 minutes. And so with that, if you like it, don't forget to hit the like button. Subscribe, please. We're seeing our subscriber count go up. We appreciate all the support that's out there. We will work very hard to keep you informed on what's going on in the Illinois legislature and other Second Amendment news. We got some more news out of Naperville and a few other things. So with that, as always, guys, thanks again for your support, and frag out.